Good afternoon, dear colleagues. It's London calling. Today, we are here to discuss Common European Sales Law in relation to formation of contracts, and watch my work move all over the screen. We have to reach an agreement whether this optional instrument or any other legal instrument is needed to fill in the gaps in the European contract law. As was already mentioned many times, harmonization of 28 different laws in the European Union can take many forms and is up to the Member States and Commission to find the best way to approach the current divergences. The Commission believes that existence of 28 different contract laws governing the sale of goods to consumers, I quote, discourages companies from cross-border trading and prevents consumers from benefiting from the most competitive offers and from the full range of online offers. It said, in a single market, companies should be able to manage their sales under a common set of rules. Maybe they should, maybe they shouldn't. We continue to support the Commission's underlying aim to improve the functioning of the internal market and encourage intra-EU cross-border trade, particularly involving consumers and small and medium-sized enterprises. We do not believe that EU contract law measure will achieve that. In line with the principles of subsidiarity and proportionality, is now placed at the center of its policy considerations by the new Commission, the Commission is bound to show that action at EU level is needed and that that action is proportionate to the problem that it seeks to address before it proceeds with an EU measure such as an CISL, or anything similar. Indeed, EU single market's cross-border trade still has barriers due to differences between contract laws, which makes selling abroad complicated and costly. Now let's get a little bit more serious. Indeed, the EU single market's cross-border trade still has barriers due to differences between contract laws, which make selling abroad complicated and costly. Those different sets of national rules can lead to additional transaction costs, a lack of legal certainty for businesses, and a lack of consumer confidence. Currently, businesses wishing to carry out cross-border transactions must adapt to the different national contract laws of the member states, translate them, and hire lawyers, costing an average €10,000 for each additional export market. However, any cross-border obstacles that may exist do not relate to differences in contract law as such, nor could they be fixed by any EU measure in the contract law field, much less CESL as previously proposed. Rather, we believe that any obstacles to cross-border sales involving consumers and small and medium-sized enterprises are attributable to other factors such as language, variable tax rates, variable advertising rules, variable internet penetration and access, etc. We note that the only possible benefit that we have ever identified that might flow from an EU contract law instrument might be the possibility to purchase a good from a trader that would not without CESL have been willing to enter the contract. We are now aware of any reliable sources Lastly, we note that the only possible benefit that we have ever identified that might flow from the EU contract law instrument might be the possibility to purchase a good from the trader that would not, without CESL, have been willing to enter a contract. We are not aware of any reliable statistics, but find it difficult to believe that this number will represent more than a small minority of possible sales to consumers in the UK or in most other member states who are already well served. If so, adopting an EU-wide contract law instrument is not a proportionate way to achieve this. Rather, reviewing aspects of the existing laws, such as the Consumer Rights Directive or the Roaming Regulation, would be the simpler, more proportionate way forward. Thank you for your attention. My colleague will continue from now on.
Now that Monica has finished with the introduction of our topic, I am going to compare the English legal system with the legal systems of France and Germany. We will first take a look at the English legal system. The English law has 5 requirements in order for someone to be able to form a contract. First of all, there needs to be an agreement between the parties. These parties need to have the intention to be legally bound to the contract. Thirdly, they need to have the capacity to contract. Fourthly, there needs to be a certainty with regards to the terms of the contract. And lastly, there needs to be a consideration or otherwise a quid pro quo. A contract usually exists when when an offer exists by the offerer and when the offeree accepts this offer. What consists of an offer is more or less similar to all the legal systems that were mentioned before, since an offer exists when the offerer has indicated exactly the terms with which he or she is prepared to be legally bound by. The question of how long does the offer last is also identical to the legal system, since it lasts for the specified time limit that the offerer has put in the beginning of the contract, or if there is no specified time limit, after a reasonable time limit has lapsed. Returning to English law, how do we know that a contract has been formed? We know that a contract has been formed when the acceptance has been communicated to the offerer, or in other words, when the acceptance has reached the offerer. In English law, there is the exception of the postal rule, which means that a contract is formed when the acceptance has been posted to the other party. Regarding French law now, the requirements in order to form a contract are less. First of all, the parties need to have the intention to be legally bound to the contract. They need to reach a sufficient agreement, and they need to perform this based on the principle of good faith. There is no consideration in civil law. What is an offer? An offer is under French law, is when the offerer has indicated the terms under which he or she is willing to be bound. The contract is the contract is formed when the offer has been accepted by the other party. The acceptance can take place in 2 different ways. When the acceptance has been dispatched by the offeree and then when the acceptance has reached the offerer. If we go to German law now, the requirements can be found in section 145 of the BGB. First of all, there needs to be an offer. Second of all, there needs to be an acceptance to the offer. Third of all, there needs to be an agreement to the essential parts of the contract, for example, the price or the place of performance. There needs to be the principle of good faith and the general principle of pacta sunt servanda. However, these legal systems, although they do look kind of similar, they do have a lot of differences. For the sake of clarity, I will make a comparison between common law and civil law. Common law emphasizes a lot the requirement of consideration, or otherwise a quid pro quo, or in other words, a bargain of exchange. English law doesn't accept gratuitous promises, and this is the reason why it is very skeptical about why would someone offer something or give something gratuitously without taking anything in exchange. This is the reason why in England donations do not count as contracts, while in civil law they do count as contracts. Consideration doesn't have necessarily to benefit the promisor, but it has to lead to the detriment of the promisee. As it was more clearly defined in the case of Curry versus Missa, a valuable consideration may consist either in some right, interest, profit, or benefit to the one party, or contrarily to some detriment, loss, or responsibility suffered by the other party. However, consideration is not a motive or a reason for a commercial transaction. On the contrary, civil law does not require any bargaining of exchange or a quid pro quo. Simply, as long as there is intention from the parties to be legally bound to the contract, they enjoy their freedom to contract, so they are able to set their own rules to the contract. Civil law, on the contrary, accepts religious promises. However, French law requires a certain cause to be present behind the contract. This can be seen by Article 1131 of the Code Civil, reading that any obligation without a cause or with a false cause or with an unlawful cause does not have any effect. Nevertheless, a cause doesn't mean that it's a bargain for exchange. Another difference is that civil law pays a lot of attention to the manifestation as well as the existence of the will of the parties. If there is only indication that the parties do not agree to the terms or they don't have an intention to be legally bound, a contract cannot be formed. In common law, there is no such thing, and parties are free to form contracts even if they don't have an intention to be legally bound, and that is the reason why a person can easily revoke a contract whenever he or she wants. Lastly, one can observe that the principle of good faith is totally absent from common law, even though it is accepted in international commercial law, such as the UNIDROIT or the CISG. Common law doesn't recognize a general duty to perform contracts based on good faith. This absence makes sense in common law due to the fact that common law does not focus on the explicit intention of the parties to be legally bound to the contract and to the fact that the offeror can revoke his or her offer whenever he or she wants. Generally, good faith in common law is only required when it is needed, for example, to make a contract work, so for matters of efficacy. Civil law embraces the principle of good faith and the contrary. This principle is based on honesty between the parties, is based on the legitimate expectations that have been created by the parties when they entered into the contract, and to the reasonableness that when someone enters into a commercial transaction, they do have the intention to be bound by it. This was a simple comparison between the common law system and the civil law system, and how these systems differ with regards to the formation of the contract.
I'm going to present you the opinion of the Scottish Law Commission on the policy options for progress towards a European contract law, and more specifically with regard to the formation of contracts. The general opinion is that there should be a reform in order to cope with the problems raised by the divergence of national contract laws in the European internal market. When it comes to business-to-business contractual relationship, the evidence gathered by the Business Advisory Group suggests that problems do currently exist with regard to the combined effects of market dominance, perception of differences, and real divergence of national laws. This leads to the conclusion that a European law of contract, perhaps in the form of a written instrument, would be welcomed by some businesses in Scotland. Nevertheless, the case for European contract law is not as strong for consumers as it is for businesses. The reason for this are twofold. Firstly, there is already a substantial body of European consumer protection law, mostly providing for a minimum level of harmonization. Secondly, Article 6, subparagraph 2 of Rome I regulation assures consumers of the continued protection of any mandatory protections afforded to them under their domestic law. There is lack of evidence to show that consumers directly suffer from the absence of harmonized contract law across the European Union. Providing a system of European contract law for B2C contracts may afford benefits for businesses, perhaps more so than for consumers. An easily accessible multi-language version of a European contract law might allow businesses to readily ascertain the consumer rights and protection applicable to their trade across EU borders and save them the expense of seeking advice on the national level of another member state. This is particularly important for small businesses. Such a system of European contract law available for use in B2C contracts has the clear possibility of stimulating further trade with foreign consumers across the internal market. A single law is not necessarily required for the effective operation of a single market. There is certainly merit in the adoption of an optional instrument. This would provide parties with a useful and attractive alternative to domestic contract law. Scotland is in favour of this optional instrument being made available in all EU member states via the medium of an EU regulation. Nevertheless, further consideration will be required on the effect of any optional instrument on the current regulations governing international private law in the EU, namely the Rome I regulation and the Rome II regulation. A substantive amendment of their provisions may be required in order to guarantee the effectiveness of any optional instrument. To conclude, the speedy creation of a body of authoritative and accessible case law on the optional instrument is of utmost importance in order to promote a consistent interpretation of it across the EU.